Hi everyone, welcome to FDA and Medical Devices, today's webinar. My name is Pia Dean, and I recognize several of your names, although I haven't had the pleasure of meeting most of you. Today we're going to be talking about a subject that we haven't really dealt with previously in our webinar series. So this is the beginning of a discussion about FDA issues, including medical devices and drugs, that I think we would like to get into. Before we start, I have to give you our usual disclaimer. Just important to remember that this is just meant as educational material. It doesn't constitute legal advice and doesn't necessarily reflect the views of on-heart attorneys other than me. We are not creating an attorney-client relationship, and if you have specific questions, it's always a very good idea to seek legal advice about specific issues that you may be seeing in your particular situation. So starting forward, here's where I think we're headed today. I'd like to give you a quick overview of the Food and Drug Administration, and I do that not because I think it's particularly interesting, but it helps to understand how the FDA is set up. It is a vast organization of more than 14,000 employees. It covers a lot of different things, and so getting to the right place is often half the battle. Then I want to take a look at different requirements that pertain specifically to medical devices. Manufacturer and establishment registration and medical device listing, a requirement for anyone who's going to put a medical device out onto the market. And then the whole issue of pre-market notification and pre-market approval. That's one of the biggest confusing spots, and I'd like to spend a little bit of time on that to try to help you understand and, more importantly, how to access information about different devices so that you know where to look and how you are able to determine what classification it's going to be given. Then determining device classifications, just what I was talking about. The investigational device exemption for clinical studies. So there's a special designation for devices that are in clinical studies or in research studies. And then I'd like to take a look at the quality system regulation and labeling requirements, and finally medical device and adverse event reporting, a very, very important part. And because that can fall onto individual practices, physicians, other providers, it's important to know what those reporting requirements are. So let's start in. As you all know, FDA is Food and Drug Administration. It's an agency within the U.S. Department of Health and Human Services. It consists of the commissioner and 4 directorates overseeing the core functions of the agency. And it's important to just sort of understand where medical devices falls in this. So these are 4 separate divisions within the FDA. The first is medical products and tobacco. The second is food and veterinary medicine. The third is global regulatory operations and policy, and the fourth is operations. The operations group is very, very large because they're doing the inspections and the like. So overall, the FDA is responsible for protecting the public health by assuring the safety, effectiveness, quality, and security of human and veterinary drugs, vaccines, and other biological products and medical devices. It's one of its core issues. The next is protecting the public health by assuring that food, and I'm going to tell you about what's exempted from that, are safe, wholesome, sanitary, and properly labeled. There is a cutout for livestock, poultry, and some egg products that can be that can make sometimes dealing in the food issues difficult to know which agency to go to. Livestock, poultry, and most egg products fall under the USDA, U.S. Department of Agriculture. But also the FDA is responsible for protecting the public from electronic product radiation, assuring cosmetic and dietary supplements are safe and properly labeled. They're also responsible for regulating tobacco products. And then this last one, advancing the public health by helping to speed product innovation. And I wanted to point this out specifically because it is a theme that you'll hear me say several times today, and that is knowing how and when to work with the FDA is an important issue to develop if you're going to be dealing with medical devices. They have a responsibility to help get products to market. They like to work with innovative new products. They like to work with manufacturers and distributors, and they are actually quite responsive as long as you can get to the right division and the right people. So I like working with the FDA. I just got to tell you that I started out in my career as a litigator. For 20 years, I litigated mostly medical device or FDA-regulated products, blood, all sorts of implantable devices and drugs, as well as I've done some food and contamination issues. And what I learned over those 20 years of litigation is that there's all sorts of ways to do things wrong that can magnify problems down the road. And ultimately, when I decided that I wanted to transition my practice, go back to school and get an advanced degree in health law, I did so because I wanted to help people function better and deal better. And one of my favorite things is working with the FDA because they can be very satisfying to work with, very responsive, and quite helpful. So that's my take on it. Just want to remind you that the FDA is responsible for all 50 states, the District of Columbia, Puerto Rico, Guam, Virgin Islands, American Samoa, and by the way, the statute reads other U.S. territories and possessions, so it covers anything that we might have control over in the future. It regulates food. So now I'm going to go through the different things that it regulates and just give you a brief overview of what that is. Food includes dietary supplements, bottled water, food additives, infant formulas, and other food products. Again, the USDA plays a role in inspecting meat, poultry, and some egg products. Looking at cosmetics, it's responsible for color additives found in makeup and other personal care products, skin moisturizers and cleaners, nail polish, and perfume. So a fairly broad field in cosmetics. And then anything that gives off radiation, which includes microwave ovens, X-ray equipment, laser products, ultrasound therapy equipment, mercury vapor lamps, sun lamps. So some of these are not medical devices, and some of them are, but that has its own special department within FDA, those electronics that give off radiation. Then for veterinary products, it includes livestock feeds, pet foods, veterinary drugs, and devices. So all the devices and drugs that are used to treat either injury or illness in animals is covered by the FDA, as well as the feeds and pet food. And then it's responsible for drugs. And this includes just about anything you can imagine in drugs. It's prescription drugs, both brand name and generic, non-prescription over-the-counter drugs, vaccine, blood and blood products, cellular and gene therapy products, tissue and tissue products, and all allergenics. In other words, drugs are obviously under the purview of the FDA. Tobacco also is. It covers cigarettes, roll your own tobacco, smokeless tobacco, and now these products that are being called ENDS. Just very recently, the FDA was given complete authority over all electronic nicotine delivery products, or what we're calling ENDS. And that includes all the e-cigarettes, vaporizers, and the like. And this includes the manufacture, import, packaging, labeling, advertising, promotion, sale, and distribution of tobacco products. So they cover just about anything having to do with tobacco. And then getting to what we're interested in, the FDA regulates medical devices. And the term medical device is a very, very, very broad term. I was at a physician practice one day, and we were talking about, just looking around the room, how many of the things sitting out in a doctor's office were covered by the FDA. So I want you to think of it in very simple terms like tongue depressors and bedpans and compresses, Band-Aids. But it also has very complex technologies, pacemakers, artificial valves, implantable knees and hips, all of those kinds of things. It also includes dental devices, surgical implants and prosthetics, both internal and external, devices used to diagnose disease or injury, devices intended to treat illness or injury, and just about any other device used by medical providers in a hospital, post-acute care facility, or clinical setting. Very, very broad. Just to give you an idea of the FDA's resources, the last time we have figures was for their fiscal year 2013. By the way, the FDA's fiscal year runs from October 1 to September 31. They had more than 14,600 full-time employees. Of that, the division that we're concerned with is going to be the devices and radiological health. There were 1,413 full-time employees in that department. By comparison, the drug group has 3,600. The food safety employs about 1,082. The Centers for Biologic Evaluation and Research employed just over 1,000, and the Office of Regulatory Affairs, which is looking at all of the regulations and constantly revising, updating, and creating new regulations, was over 5,000. So it gives you an idea of the breakdown. The Federal Food, Drug, and Cosmetic Act is the primary act, and it is the act that created the FDA. It was enacted by Congress, and I've given you the site for it. It's a very large, very dense law. The Act and other federal laws establish the legal framework with which the FDA operates. The FDA develops regulations following the procedures required by the Administrative Procedure Act, which means that they go through a distinct and set process for creating new regulations. Most are by a notice and comment rulemaking, which basically allows the public to provide input on proposed regulations before the FDA issues a final rule. Right now, there are literally hundreds of proposed FDA regulations out there that are open for public comment, or public comment is closed and the FDA is finalizing. But one of the important things that health lawyers do is look at proposed regulations and help different sectors within the healthcare industry provide comments to the FDA to try to get regulations that are what is needed by the industry at the time. And then the other thing that the FDA provides and puts out a great deal of are what is known as good guidance practices. We just refer to them as guidance. Guidance is not legally binding on the public or the FDA, but it is a very good way of understanding how the FDA is currently thinking about a regulatory issue. And there are numerous guidances out there. They are not difficult to find. You can even Google FDA and a particular issue, and you're likely to get to a guidance. The better way is to go into the FDA website and do a search. But there are guidances on everything. They are coming out constantly, and we rely on them very heavily to understand where the FDA is headed in terms of the regulation of a particular device or product. And one thing that we should talk about is the fact that there is so much happening in medical devices right now. There is always progress, obviously, but what is happening in the world of medical apps and mobile apps has proliferated greatly, and there is a lot going on. And so some of those original medical apps, the FDA came out and were wanting to regulate more heavily and have since backed off of. And I'll give you an example of that later as we move forward. But there is a constant proliferation of new devices, new ideas, new apps that the FDA is working on, and it is really a fun part of lawyers' jobs to get a chance to work with healthcare providers who have new ideas or better ways of doing things. And it can be as simple as a surgeon saying, there's a better device that we could use for this particular procedure. And you can imagine with the onslaught of arthroscopic surgery, there were lots and lots and lots of new medical devices that came out of that. But it's also other kinds of medical practitioners. I was approached recently by a physical therapist who sees the need for a splint for some sort of, for people who do lots of yoga, and is likely going to bring that product to market. And so for a lot of these medical providers or physician practices, hospitals and the like, they see better ways of doing things, and yet they're not sure what they are required to do if they want to put out a better product. Even if they just want to create a device that they're going to use just for themselves and not distribute it, they aren't sure how and what are the requirements for creating that. So that is why the FDA and its regulation of medical devices is important to understand. I just want to give you a quick idea of the overlapping agencies. The FTC regulates many types of advertising, although the FDA has a role in advertising. We'll get to that. The Department of Treasury's Alcohol and Tobacco Tax and Trade Bureau regulates aspects of alcohol production, importation, wholesale, distribution, labeling, and advertising. So alcohol is primarily not under the FDA. The Consumer Product Safety Commission regulates the safety of consumer products such as toys, cribs, power tools, lighters, basically anything that poses a fire, electrical, chemical, or mechanical hazard. So that does not fall under the FDA. And as we've mentioned, the USDA regulates aspects of safety and labeling of traditional meats. I've misspelled that, I apologize. Poultry and certain egg products. And the Environmental Protection Agency regulates pesticides and the types and amounts that can be used during growing and how much can remain in foods. So the EPA is the agency that is dealing with the growing conditions and pesticides used in our foods. So I want to give you an idea of what is under the particular office we were talking about. So you'll recall several slides ago I said that there were basically 4 offices, and one is Medical Products and Tobacco Organization. And within that, there are multiple subdivisions. We are interested in the third one, the Center for Devices and Radiological Health, but there are also Drug Evaluation and Research, Biologics Evaluation, Tobacco Products, Special Programs, Combination Products, Good Clinical Practices, Pediatric Therapeutics, and Orphan Products Development. I'm not going to go into any of those others besides the devices for radiological health, because that is the center that deals with the kinds of medical devices that we typically are associated with. So the Center for Devices and Radiological Health, you'll also see it just called CDRH. It's responsible for protecting and promoting public health, obviously the very broad goal. It's tasked with providing consumers, patients, their caregivers, and providers with understandable and accessible science-based information about the products FDA oversees. And I got to tell you, in my experience, I think that the FDA takes this obligation very seriously. The FDA's website is massive, but it has a lot of information, and it's not very difficult to search. I think it's a particularly a good, one of our better governmental websites. And they do take this idea to heart, that the idea is to provide accessible science-based information for medical devices. They also have a duty to facilitate medical device innovation by advancing regulatory science, providing industry with predictable, consistent, transparent, and efficient regulatory pathways, and assuring consumer confidence in devices marketed in the U.S. That goes back to a point that I was making earlier, and that is they do have an obligation, and I think they take it seriously, to work with manufacturers and distributors to get products to market and to make it as simple as possible. Obviously, we all know that there's lots of criticism of the FDA, and I don't mean to diminish that criticism of how long it takes to get a product to market and how expensive and difficult that can be. All I'm saying is that if you can get into you can find the right niche where your device is, you can work with the FDA, and they will try to work with you in conjunction. It does not mean that we've made it simple to get medical devices or drugs to market, but they do make an effort to work with industry. And I've been pleasantly surprised when I started working in the preventative law sector as opposed to litigation at how accommodating they can be. So the regulations extend to firms who manufacture, repackage, relabel, and or import medical devices sold in the United States. So I want you to think about that. It's manufacture, repackage, relabel, or import. And it is those categories because if you are repackaging or relabeling a product, you may be changing its use, so the regulations apply to you. If you're manufacturing it, obviously it applies to you. And then if you're importing a medical device that will be sold in the U.S., those regulations also apply. Manufacturers, both domestic and foreign, and initial distributors, importers, of medical devices must register their establishments with the FDA. So if you fall within that group of entities, you must register your entity, your business, your facility with the FDA. And establishment registrations must be submitted electronically unless a waiver has been granted. That's a relatively recent development. Now you have to specifically ask for a waiver to submit in paper form. They now prefer electronic submissions, and you'll see that throughout the FDA. They've gone pretty electronic. Registration information must be verified annually between October 1st and December 31st. So in the last quarter of the calendar year is when registration information must be verified. Foreign manufacturers must also designate a U.S. agent. So foreign manufacturers must have a U.S. agent that they provide that information for to the FDA. And there is an annual registration fee. And you'll note that I've put in parentheses, which is not eligible for a reduced small business fee. I put that in because there are other aspects of what the FDA does that if you fall within the definition of a small business, the charge or fee is reduced. But that is not true for the annual registration. For the fiscal year 2016, the annual registration fee was $3,845. That was not a significant rise from the year before. They're estimating that for the next year, for 2017, it will only go up by about $30. However, that will not be determined and posted until August of 2016. So that'll come through. We'll see if they, in fact, have that low an increase. The increases over the last couple of years have been fairly reasonable. There was a, between 2010 and 2011, there was more than a $500 jump that caused a lot of angst for people. And I've given you the site there, or the link to who must register, list, and pay the fee, just so that you have it and can look it up. So in addition to providing information about the establishment, registering the establishment that is either producing or distributing or exporting a device, manufacturers must also list their devices with the FDA and the activities that are performed on those devices. So establishments are required to list their devices. Those that are required to list their devices include manufacturers, contract manufacturers that commercially distribute the device, contract sterilizers that commercially distribute the device, repackagers and relabelers, specification developers, and I'll get to them in just a minute, reprocessors of single-use devices, remanufacturers, manufacturers of accessories or components sold directly to the end user, and U.S. manufacturers of export-only devices. So all of those groups must register their devices and provide information about those devices. For FDA purposes, medical devices are categorized into 3 classes. So I want to just take a little break here and tell you where I want to go with this, and I hope you're okay with it. One of the most difficult things for my clients to understand is how devices are classified and what the classification means in terms of having to get approval from the FDA, clearance from the FDA, and what other requirements are necessary before they can put a medical device in use. They 3 classifications. There's only 3, and they typically are referred to as Roman numeral 1, Roman numeral 2, and Roman numeral 3, although the FDA now is starting to use the numerals as opposed to the Roman numerals more and more. But Class 1 medical devices are those that present the lowest risk of causing harm. So think the tongue depressor, think the cotton pad, think the bandage, and correspondingly are subject to the lowest degree of FDA regulation. Most Class 1 devices are exempt from pre-market notification. Now, by pre-market notification, that means notification and proof to the FDA that a product is safe and effective, okay? Class 2 devices have some potential of harm and typically require a pre-market approval, and it's often, you'll just often see it referred to as 510K because that's the section of the code that it's in. Some Class 2 devices are also exempt from pre-market notification, and we're going to run through an example, so I hope that this will become clearer. And then Class 3 devices present significant risk, and most require pre-market approval. Premarket approval is different from premarket notification. We're going to get to that, but it is just a jump in terms of what has to be proved to the FDA about the safety and effectiveness of a product. So, for instance, just about any device that is implanted into the body, a pacemaker, a heart valve, a knee, a hip, an ankle, any of those are going to be Class 3 devices. And to get a Class 3 device to market, you're going to have to go through the pre-market approval process with the FDA, and that is almost surely going to involve clinical studies, research, and validated scientific methods. Each entity or individual who wants to market in the U.S. a Class 1, a Class 2, or a Class 3 device intended for human use, and for which a pre-market approval is not required, must submit a 510K to the FDA unless the device is exempt from 510K requirements. That's a mouthful, and that's right out of the code. But I just want to say it one more time. If you are going to market either a 1, 2, or 3 device intended for human use that does not require PMA, so pre-market approval, you must submit a 510K unless the device is exempt. And I'm going to run through an example. I'm actually going to run through a couple of examples so that you can see how you determine this and figure it out, because it's very confusing. Making matters worse, there is no standardized 510K form, but I've given you the site there. Section 807 subpart E describes the requirements for a 510K submission. So that's what must go into it, but there is no set form. It would be nice if there was. The FDA has played with this idea of a 510K form and routinely rejected it because the difference between devices and other medical products are so great that they feel like there is no form that could cover it all. So rather they give us a description of the requirements and allow us to do our own 510K submissions. Before marketing a device, each applicant must receive an order in the form of a letter from the FDA which finds the device to be substantially equivalent and states the device can be marketed in the U.S. We're going to get to substantial equivalence in just a second. I just want to just sort of run over a couple things there. So the FDA does not technically approve a medical device or other medical product. It clears that device. And so what happens is, if you are required to go through the 510K process, you submit an application to the FDA and you get back a letter from the FDA saying this medical device has been cleared for market. And it is literally just a form letter, but that is the way it works. And again, we don't talk in terms of approval, we talk in terms of clearance. So the 510K is a pre-market submission made to the FDA to demonstrate that the device has been marketed, the device to be marketed as at least as safe and effective, substantially equivalent to a legally marketed device that is not subject to PMA. Okay, again, so now we're dealing with devices that do not have to go through the pre-market approval process. That is the highest level of scrutiny, usually involving validated scientific research or clinical study. And to get a 510K clearance from the FDA, the easiest way to do it is to prove that the product you're putting onto the market is substantially equivalent to another device that has already been cleared by the FDA. Submitters must compare their device to one or more similar legally marketed devices, which we call predicate devices, and make and support their substantial equivalency claims. We do this a lot. So what this entails is, say I'm working with a provider group that says we have come up with a particularly good kind of knee brace, and we want to distribute it. So the first question that you have to ask is, what kind of clearance is it going to require from the FDA? So is it an exempt device? Is it a Class 1 or a Class 2? If it's either one of those, is it exempt from a 510K? And if it's not exempt, is there another device that is already out there with FDA clearance that it is substantially equivalent to, such that we do not have to do anything other than show that our new device is substantially equivalent to a legally marketed device. And by legally marketed, I mean already has received FDA clearance. I hope that makes sense. A legally marketed device is a device that was legally marketed prior to May 28, 1976, we call these pre-amendments devices. They do not require a 510K process, and they're also the devices that do not require a PMA. I hate to admit it, but when I started practicing law, there were several devices that actually fit within that time frame that were brought to market legally prior to May 28, 1976. We see it less and less now. So there's less of these grandfathered devices. Or a legally marketed device can be a device which has been reclassified from a Class 3 to a Class 2 or 1. And you think, well, how often would that happen? It's actually happened with a large number of devices in the new world of medical apps. So when several medical apps, especially relating to telehealth and the transmission of health information to mobile uses, for mobile uses, a lot of those were originally classified or required Class 3 status. And they have since, by the FDA, because we've become so standardized and we realize how good that process has become, have been reclassified to a 2 or a 1. So if something has gone through the rigors of a Class 3 clearance, if it's reclassified to a 2 or 1, it does not need a new approval basis from the FDA. And then the third of these points is the most common way that we go about getting clearance, and that is a device is found to be substantially equivalent through the 510K process. Again, we're going to walk through an example. Until the applicant receives an order declaring the device substantially equivalent, the device cannot be marketed in the U.S. I can't stress that enough. If you are going to legally market a device, it must either be exempt from pre-market notification or it must have received pre-market notification, typically through the 510K process. Substantially equivalent determinations are made typically within 90 days. That's if you provide all the necessary information. They're pretty good about getting those out. And a manufacturer should be prepared for an FDA quality system inspection anytime after a 510K clearance. One of the onerous aspects of the FDA is that once you are registered and a product has been cleared for market, the FDA can inspect it anytime without notice. More importantly, if the FDA has reason to believe that something is going terribly wrong in the manufacturing process that poses a risk of injury to human or serious injury or death, they can come in and shut down the manufacturing process summarily. So it's something it's important. I just wanted to make you aware that that any manufacturer, once they've gone through the 510K process, the pre-market notification process, can be inspected. So let's talk about substantial equivalence. Substantial equivalence means the new device is at least as safe and effective as the predicate device. A device is substantially equivalent if, in comparison to the predicate, it has the same intended use as the predicate and the same technological characteristics as the predicate, or has the same intended use as the predicate and has different technological characteristics, and the information submitted to the FDA does not raise new questions of safety and effectiveness and demonstrates that the device is at least as safe and effective as the legally marketed device. So let's just talk about a very practical way in which this happens. You have a device that used analog technology. The new device is used for the exact same purpose but now uses digital. The FDA does not have a problem with that. It says that we know enough about digital technology now that the new technology in the new device will still make it substantially equivalent to the predicate device. Now, substantial equivalence does not mean the new and predicate devices are identical. Substantial equivalence is established with respect to intended use, design, energy used or delivered, materials, chemical composition, manufacturing process, performance, safety, effectiveness, labeling, biocompatibility standards, and other characteristics is applicable. Again, there's no set rule from the FDA on this. Rather, you take a look at your product, you compare it to a predicate device, and then you make your case to the FDA as to why it is substantially equivalent and therefore should receive pre-market notification. Just reminding you there on that next point that, again, until the submitter receives a letter declaring the device is substantially equivalent, it cannot be marketed legally. What happens if the FDA determines the device is not substantially equivalent? Well, in that case, the applicant can resubmit another 510K with new data, basically making a better case that it is substantially equivalent. They can request a Class 1 or Class 2 designation through the de novo process, and I'm going to give you a site for the de novo process, but that's beyond what we're capable of covering today. They can file a reclassification petition, or they can submit a pre-market approval application, that being the most onerous, expensive, and time-consuming pre-market approval process for Class 3 devices. So basically, if the FDA comes back and says, your device does not meet a predicate device, and in fact is such new technology that there's nothing out there to use as a predicate, you are basically stuck with going through the pre-market approval process. Again, that's typically not the course we want to take because it is time-consuming and very, very expensive, labor-intensive. But all new drugs are going to go through a pre-market approval process. Most brand-new devices that are new technology are going to do the same and are working hand in hand with the FDA on clinical trials for that purpose. And later this summer, we're going to do a presentation on clinical trials for any of you out there who are either involved in clinical trials or are considering getting involved in clinical trials. It can be really interesting and very, very fun, but the FDA regulates those clinical trials to a large degree. So determining who is required to submit a 510K. Again, as I mentioned, the Act does not specify who must apply for a 510K. There's not very black and white laws on this, and that's unfortunate. Lots of people, because of that, feel like the FDA is this nebulous thing that's very hard to work with, and that it's more of an art form than a straight legal analysis. You do get a feel for the FDA the more that you work with it, but what's the important part is to understand the concepts, and once you understand the concepts, it gets easier and easier to work with the FDA. So what the regulations do specify is which actions require a 510K submission. They include 4 basic categories or actions that require a 510K submission. So, number 1, domestic manufacturers introducing a device to the U.S. market. Specification developers introducing a device to the U.S. market, and I told you we'd get to specification developers. What do we mean by that? A specification developer is an individual or entity that develops the specifications for a finished device but has the device manufactured under contract by another firm or entity. It happens a lot with the new disruptive medical innovations out there. They come up with an idea. It may be an app. It may be a mobile app. It could be any number of things. And the ideas are all there, but the product itself is going to be created by a contract manufacturer. In that case, the specification developer is responsible for the 510K. As I say there, the specification developer must submit the 510K, not the contract manufacturer. Number 3, repackagers or relabelers who make labeling changes or whose operations significantly affect the device. Significant labeling changes may include modification of manuals, such as adding a new intended use, deleting or adding warnings, or contraindications. Likewise, operations such as sterilization can alter the condition of a device, but I just want to tell you, in most cases, repackagers and relabelers are not required to submit a 510K device. It's only in the case that they are substantially altering the device or changing its intended use. So again, if you're taking a medical device and using it for off-label purposes and marketing it for that purpose, advertising it for that purpose, labeling it for that purpose, then that would require a 510K. But most repackagers and relabelers are not required to submit a 510K. And the fourth general category is foreign manufacturers and exporters, or U.S. representatives of foreign manufacturers and exporters introducing a device to the U.S. market. A 510K is required, as I said, when introducing a device into commercial distribution for the first time. So after May 28, 1976, the effective date of the medical device amendments to the Act, anyone who wants to sell a device in the U.S. is required to make a 510K submission at least 90 days prior to the offering of the device for sale, even though it's under clinical development or clinical investigation. Number two, 510K is required when the applicant is proposing a different intended use for the device, which is already has a commercial distribution. So if you've figured out a new use for an existing product, it still will require a new 510K submission to look at the safety and efficiency or effectiveness of that device for the new intended use. Number three, there's a change or modification of a legally marketed device, and that change could significantly affect its safety or effectiveness. Again, we come back to this nebulous concept that there is no form and there's no specific requirements, and this adds to it. The burden is on the 510K holder to decide whether or not a modification could significantly affect the safety and effectiveness of a device. Any modifications must be made in accordance with the quality system regulation and recorded in the device master record and change control records. And my strong recommendation is the best practice is to record the justification for submitting or not submitting a new 510K in the change control records. So if you are looking at taking an existing device and marketing it for some other purpose, there has to be some analysis on your part as to whether or not it requires a new 510K. And no matter what you decide, I would strongly recommend that you document that decision process and your reasoning for that, because it can come back to protect you in a very big way. Now, the following couple of slides are when a 510K is not required. You sell unfinished devices to another firm for further processing or sell components to be used in the assembling of devices by other firms. Again, this is the typical component part manufacturer who is providing components that are going to be used in a device assembled and distributed by another. That does not require a 510K. Your device is not being marketed or commercially distributed. 510Ks are not needed to develop, evaluate, or test a device, including clinical evaluations. That's going to come under the investigational device exemption. So it's only if you're going to market and sell a product. You distribute another firm's domestically manufactured device. There you can simply indicate that you're distributing it or that it's manufactured by a different firm. That does not require a 510K pre-market notification clearance. In most cases, if you are a repackager, that should be, or a relabeler, you are not required to submit a 510K if the existing labeling or condition of the device is not significantly changed, just what we said a moment ago. You have proof that your device was legally in commercial distribution before May 28th. Those are grandfathered in. Again, a 510K is not necessary unless the device has been significantly modified or has been a change in its intended use. And you might ask, you know, what are the chances that we'd be dealing with some products that go back into the 70s? There are still some things like straps that hold oxygen masks in place, or other connectors and the like that can still use grandfathered processes because they're not changed. But for the most part, those grandfathered predicates are falling by the wayside. You're also not required to file a 510K if the device is made outside the U.S. and you are an importer of a foreign-made medical device. So a 510K is not required if one has already been submitted by the foreign manufacturer. And by the way, the foreign manufacturer is required to submit a 510K and received marketing clearance. Once the foreign manufacturer has received 510K clearance for the device, the foreign manufacturer may export its device through a U.S. importer. The U.S. importer does not need any additional clearance from the FDA. I work with a company out of Canada, and we use this importer exception a lot. But that Canadian company has to get its own FDA clearance. The importer, however, that is selling the product in the States does not need to. And then again, we come back to your devices exempted under the from 510K by regulation. So certain Class 1 and Class 2 devices can be marketed for the first time without having to submit a 510K. That is called an exempt device. The exempt devices, there is a list of them. It's very big, and I've given you the site to it. And the next slide contains the opening page of that. And you can see the subparts in the code. You can click on these when you're in the website, and you can start to pair out all of those devices which are exempted from pre-market notification. So everything from tongue depressors, which bear almost no threat for human injury, to things like bandages, external bandages, that is, cotton balls, all of those kinds of things, swabs. They're going to be exempt, and you will find them under these various categories. Obviously, you're going to find a lot of them in the clinical chemistry and toxicology devices, but there's all sorts of them that are, in fact, exempt. And to make this point clearer, I thought we could go through an example that might help you understand how you would find this information if you're looking on a particular product. So we're going to get to that, but at first just want to cover pre-market approval. Products requiring pre-market approvals, these are these Class 3 devices, are the ones that pose significant risk of illness or injury, or devices found not substantially equivalent to Class 1 and Class 2 predicate devices through the 510K. So if you have a device that is not exempt from pre-market notification and you can't get them through the pre-market notification any other way by being substantially equivalent or grandfathered in, then you have to go through the pre-market approval process. Again, expensive, time-consuming, and requires validated research. Like I say there, the PMA process involves scientific and regulatory review to evaluate the safety and effectiveness of a Class 3 medical device. Safety and efficacy is typically demonstrated through clinical trials and scientifically validated research. Just try to remember that Class 3 devices are those that support or sustain human life, are of substantial importance in preventing impairment of human health, or which present a potential unreasonable risk of illness or injury. And the FDA will not approve such a device under the pre-market approval plan without sufficient valid scientific evidence to assure that the device is safe and effective for its intended use. Again, we're just not going to put a heart valve out there that hasn't been excessively studied through clinical trials. The same thing is true of any other device that has that kind of import on human life. The PMA applicant is typically the person who owns the rights or otherwise has authorized access to the data or other information to be submitted in support of FDA approval. This person may be an individual, partnership, corporation, association, scientific or academic establishment, governmental agency or organizational unit, or other legal entity. Very often, these are large companies that are putting out devices. You can think of any medical device company that provides lots of equipment or devices. They are going to have a large research and development arm. They are going to be the inventor and developer of the product. But it also happens in much smaller places. It happens in medical offices that say we have a better way of doing this and we ought to put this instrument out there that makes an arthroscopic surgery easier or improves the way this implant functions over the long run. It happens with physical therapists. It happens with occupational therapists. So it isn't just large manufacturing concerns that we all think of as the big medical device producers. It's happening with small entrepreneurs in medical apps and mobile apps. It's happening in clinical practices all over. And it's surprising how often that can be a wonderful development for that particular small practice or individual. I mentioned that I was going to give you information on the de novo process. So if a device does not receive clearance, there is a de novo process, and I've given you the site for that. I know that we're running out of time, so I won't go through the de novo process, but there is a good explanation of the de novo process, and I just wanted to give you a site for that so that you have it. So how do you determine a device's classification? The FDA has established classifications for approximately 1,700 generic types of devices and grouped them into 16 medical specialties that they refer to as panels. There are two different ways to determine the classification of a device. You can either use the product code classification database or the device panel database. And I want to run you through this just so that you know how to do it and you don't feel intimidated when you start looking for how a device is classified. So if you're going to use the product code classification database, I've given you the site, you go to that, and you'll see this particular slide pop up. You put in your search term. So, for example, if you're looking for a snoring cessation device or you're thinking about manufacturing or distributing a snoring cessation device, say you've come up with an idea that you think will help snorers, you can put in the search term snoring. You also then want to include whether it's an implanted device and whether it's a life-sustaining support device. Using just these search terms, you can often come up with the appropriate section of the code and all sorts of information about these particular products. So here you'll see that I've just taken a snapshot that shows that under the device we've put snoring, that it's not implanted, and that it's not life-sustaining. And when you put that in, you get the following, which is a wonderful piece of information. This is what you want to get to. So what we find out is that anti-snoring devices are regulated under 872.5570. That's a part of the code, gives you lots of information. It also tells you that it is not exempt. So these devices are not automatically exempt, which means that you're going to have to go through a pre-market notification process to bring this product to market. Now, these devices can cover all sorts of things. They can be intraoral. They can be something that is worn around the head. They can be something that is placed around the neck. Some of them are as simple as straps, and some of them are things that are inserted into the mouth. But the FDA has made the determination that all of the devices that fall within 872.5570 are not exempt from pre-market notification requirements, and as you can see, they are Class 2 devices. So you'll see the device Class 2. The other thing that this information gives us is the TPLC product code report. That's the total product life cycle report, which is a very important way of looking at problems for a particular device or device type. So as I've said here on this next slide, looking at this, there are multiple key pieces of information on this page. This is the page you want to get to when you're either looking at bringing a device to market or you're considering how you would develop a product or a device and what would be required. So the important parts are the 7-digit regulation number, that's the 8725570, the classification of the device, which is 2, whether the device is exempt from GMP, good manufacturing practices, that is whether or not it has to go through the 510K process, and then a link to the total product life cycle report, which provides pre-market review, device problems, and recall information. Can be very, very helpful when you're looking at a new device. Now, there are times that using common search terms won't suffice. So no matter what search term you put into the previous slides that I showed you, you're not going to get what you want. For instance, if you wanted to look at a knee brace and you type in knee brace, it comes up with nothing. It says no search results found. Same thing's true when you put in knee prosthesis. Nothing helps. And so I often think that when you're coming up zeros, you go to the device panel database. It's just a different database. It doesn't contain different laws or different code sections. It's just a different way of getting to the same information. So as I mentioned, the FDA has created 16 medical categories they refer to as panels. Each panel corresponds to a section of the Code of Federal Regulations. And this next slide provides you with those 16 different groupings. So you're looking at anesthesiology, cardiovascular, chemistry, dental. If you work down, you see ophthalmic, orthopedic, pathology, any number of these. General surgery, general and plastic surgery is a huge category. And so what you do with this information is you take this 3-part code, 876 for gastroenterology and urology, and you put it into, you go to this link, and then you put in your information. So here, under this section part, you would put in the three-digit code and then a search term. And when you do so, what you get, I'm just telling you there, you're going to get a response. So if we were looking at the knee brace example, we could use the 888, which is orthopedic, and then put in the search term knee brace. You can get to the same results by putting in 890, which is physical medicine, and putting in knee brace. Either one of those will get you to the same place. And so as you can see from this next slide, I've just done that exactly thing. I put in 888 for orthopedic and knee brace. And it will produce the 7-digit regulation report, just exactly the same thing we saw on the previous search protocol. And it pulls up something that looks like this. And here you're looking at a knee cage, finger-sucking devices, and the like, but you look down and you find 890-3475, which is an external knee joint brace. And when you click on that, you come back to the exact same page we saw in the previous search method. Again, it tells you what the regulation number is that's important that goes to the code. It tells you that the device is a Class 1 device, and that, most importantly, it's exempt. So knee braces, external knee braces, because they have so little risk of injury to humans, you don't have to go through a pre-market approval, and you don't have to, or a pre-market notification, and you're not going to have to get any kind of clearance from the FDA. This is important for instance, this physical therapist who came to see me and said I wanted to come up with a splint. He wants to come up with a splint process for people who are getting injured doing yoga. What we know by doing a little bit of a search is that he can accomplish that without any kind of pre-market approval. Now, he is still putting out a Class 1 device under the market, which means he's going to have an establishment registration and a device registration. I hope that gives you some idea of how you would go through this. Now, unfortunately, I've never done this presentation before, and I have overestimated what I could cover in an hour, and I don't want to run over and be insensitive to your time constraints. But the next slides cover other important aspects of the FDA, but they're very self-explanatory. I go through the investigational device exemption, which is what you do for clinical trials, devices that are being used for that purpose. Then there's a quality system regulations that you need to be aware of. Then there are the labeling issues. The thing that I most want to make you aware of is that labeling can affect whether a product is considered a new use or the old intended use. So changing labeling can dramatically affect the classification and whether or not you have to go through a pre-market notification purpose. The other thing that I want to make you aware of is that there's a Court of Appeals case out there that basically says advertising is labeling. So it pertains not to just what's on the back of the device or on the package of the device. It can also extend to posters, tags, pamphlets, circulars, booklets, brochures, instruction books, direction sheets, fillers, and the like. So it's very important that your labeling, that labeling matches advertising. Then the last thing that I've covered here are the mandatory device reporting. This is an important area. I would assume that most of you that are in clinical practices are aware of what your responsibilities are here, but if you're not sure, I've tried to provide the summaries of the forms, the timing requirements, and who is required to report. User facility reporting requirements, that's what most of you guys fall under, our user facility reporting requirements. Those are fairly self-explanatory, but there's also links in here to the important parts of the FDA website that will go through that with you. There's a summary of the mandatory reporting requirements for user facilities. And then complaint files and device reporting, this is how you access those. And then reporting of an emergency. So if, for instance, you have someone come into your practice who is having a significant issue with a medical device, typically an implanted medical device or a device that they are dependent on, there is a way to report that 24 hours, 24/7 by voice or fax, and that's usually a very good thing to do. I've also given you a way or some information about searching medical device reports just so you can take a look at that. And finally, I've given a couple of concluding thoughts, just one that I want to push in the last minute that we have here, and that is that there are many people out there who still believe that it is better to ask for forgiveness than permission when dealing with the FDA, and I can't tell you how much I disagree with that. I have litigated now cases over years where the FDA, in addition to someone being hurt, the FDA is saying that the representation made by the manufacturer or developer of the medical device was inadequate or a misrepresentation or fraudulent, or they weren't, they hadn't gone through the proper testing and pre-market approval process, and that just causes a world of hurt. Those entities typically do not survive. They end up being bankrupted and the like, and they are forever on the FDA's blacklist. We've seen it over and over and over again. So I urge you that if you feel like you have a problem, it is better to seek legal counsel, work with that counsel on how you're going to approach the FDA. I don't think you just pick up the phone and call them. You typically want a remedial plan in place and the like, but that you deal with the FDA up front, and that I just can't urge that enough. After 28 years of practicing law, I've come to think of the FDA as a better friend than an enemy by all stretches of the imagination. And working with them honestly and openly can alleviate many, many, many problems down the road. The other thing there I've suggested is when developing a device, a plan for developing that, and those are just simple steps. But I think a plan is very, very important, whether you're dealing with a Class 1 or Class 2 device, and then obviously if you're dealing with a Class 3 device that you want to bring to market or somehow distribute, you want a very, very, very detailed plan, and you're going to have one because of the research and clinical trial requirements. So I'm sorry to have gone over and rushed through this. If you have questions or want additional information, please let me know. Likewise, if you would like to see us do more on FDA requirements and the like, we're glad to. As I mentioned, there will be a program on clinical trials later this summer, which works hand in glove with the FDA in terms of what is required and obtaining their approval and pre-approval on multiple aspects. So again, thank you for attending. If you have questions, please don't hesitate to call me. I'm glad to talk to you anytime. And please let us know if you have suggestions or thoughts about how we can do a better job of presenting the webinars and information to you, or if there are particular topics that you'd like to see us cover. Thanks again. Have a good day. Bye-bye.